Welcome to Address the Harm podcast. I'm Leah Brown, FRSA, founder of the Wayfinders Group and architect of the Coalition for Institutional Accountability. Please be aware that this podcast discusses difficult topics, including violence, abuse, and suicide. Listener discretion is advised. Now, this podcast centres the voices that Britain's institutions work hardest to silence: survivors of institutional harm. From NHS failures to police cover-ups, survivors have become unwilling experts in institutional failure. They know what went wrong, why it keeps happening, and how to stop it. And yet institutions rarely ask them. But on Address the Harm, we do. Survivors here share not just their stories, but their blueprint for prevention. Because when institutions finally listen to those that they've failed, that's when real accountability becomes possible. It's time to address the harm so survivors can heal. Today on Address the Harm podcast, we are joined by two guests, Cristina and Odone and Julia Margo from Fair Hearing. Cristina is founder and CEO of Fair Hearing, working to improve domestic abuse victims' access to justice. A respected journalist and broadcaster, she's been deputy editor of The New Statesman and a columnist for the major publications including The Observer and The Guardian. As head of family policy at the Centre for Social Justice, her report on domestic abuse led to government commitments of £283 million for victim support in the 2021 budget. She serves on the Cross-Department Family Policy Advisory Group and convenes high-level Westminster roundtables, including one at the Old Bailey, attended by 8 High Court judges. Julia Margo is Deputy CEO of Fair Hearing and a domestic abuse survivor who transforms lived experience into systemic change. After enduring 10 years of litigation and 37 court hearings, she's mentored over 75 survivors and trained over 200 senior judges on domestic abuse. Her work has established training manuals for the Judicial College, and that means domestic abuse education is now part of annual training for Crown and criminal courts. With 15 years in think tanks as acting CEO of Demos and Director of Research at IPPR, Julia combines survivor insight with policy expertise to drive judicial reform. Now, since recording with Cristina and Julia, amazingly there has been progress in the form of a landmark change whereby serious sex offenders who have abused their own child will automatically lose parental responsibility and therefore access to the family courts via an amendment to the Victims and Courts Bill. Fair Hearing also worked to secure an additional amendment in the same bill to restrict parental responsibility for those convicted of offending against any child. In the same week, the government announced its intention to repeal the presumption of contact recital in the Children's Act in recognition of concerns about contact being ordered, even in cases of serious domestic abuse. We'll come back to this in our bonus episode after this one, but what a panel. Welcome to Address the Harm. Thank you to you both so much for being willing to join the podcast today. It's great to have you as a part of this conversation. So I'm hoping that we can set the foundation about how complaint systems currently fail survivors. Cristina, from your policy perspective, what are the fundamental flaws in how institutions handle domestic abuse complaints?
Well, if we focus on family courts, because that is where a domestic abuse victim will go in order to secure protective orders for herself so that she keeps herself safe from her perpetrator, or let me point out, it could be a him who is the victim, but also where the victim of domestic abuse will go in order to secure safety for their child, in order to challenge those courts that prescribe direct contact with the child. So with the family court as the perfect arena in which the domestic abuse tragedy unfolds, we've got 3 key elements that are affecting the institution and that are hindering fair hearing. And the first, as always, is money. You've got, since the 2012 Legal Aid Act, 80% of legal aid was cut for private family law cases. And that has meant that so many victims of domestic abuse who are just above the new threshold for legal aid are unable to find any kind of legal support for their case. And so this affects the volume of cases that go through the family courts because...
And the complexity of them, and just the ability of victims to represent themselves fairly. I mean, imagine that between 40 and 60% of domestic abuse victims are self-representing in the legal system, and most of them have no idea how the process works and no idea, if they're unhappy with how the process has gone, how to appeal. And in fact, the appeal process, when you're unhappy with a judicial decision, is an absolute joke. It's incredibly difficult to have one's concerns voiced or heard, particularly if you're a litigant in person.
But in terms of the institution, it's the volume of cases that, because we suddenly have so many litigants in person, and because their cases take much longer, because as Julia said, they're much more likely to be complicated, and they're much less likely to have that kind of sharp legal. It affects the volume of cases that are currently overwhelming the family courts, because as Julia pointed out, the cases that are coming through are much more complex, much more complicated. Litigants in person cases take a lot longer, and the volume means that we cannot be sure that the kind of scrutiny, the kind of risk assessment that are so crucial in domestic abuse cases is properly being carried out. The third factor that I think is really, really important in looking at the institution of family courts is dodgy psychology. Too many judges, too many legal experts have fallen for the theories of parental alienation, whereby the domestic abuse victim has been alienating the child from their parent. And too many have fallen for the other dodgy psychological theory that parental contact, direct parental contact, should be there at all costs, no matter what the circumstances, no matter what the recorded allegations of abuse are. That kind of dodgy psychology was really exposed only this summer by a Women's Aid report that showed that 19 children were killed over the past 18 years by a parent who had been accused of domestic abuse. That's 19 children over 18 years. It just exposes a family court that is riddled with safeguarding issues, but also that limits a fair access to justice.
Now, one of the challenges there is that not only do they go to the courts to get a remedy, but they go to the courts so that their nightmares can end. How are these processes re-traumatizing survivors?
There's one person who can tell you that, and that is Julia, who had to undergo 37 hearings in family courts.
Yeah, my interest in the way that the family courts fail victims was born out of my own experience, and that's really what prompted us to set up Fair Hearing. I've since mentored over 100 victims of domestic abuse through their sort of family justice process, which can also include the criminal courts as well as the family courts, of course, of domestic abuse. I mean, the whole way that the family courts are set up, as identified by the Harm Report in 2020, is problematic in a domestic abuse or coercive control situation, because you've got, applicant pitted against responder, which instantly aggravates tensions. There's cross-examination, cross allegations. I was accused, my ex-partner is a convicted paedophile who the local authority banned from having direct contact with my children. And he took me to court. And I felt that I was in the middle of an argument that was between him and the local authority and the police. I had nothing to do with his conviction history. I didn't know about it. Did not want anything to do with him once I found out about it, and agreed that he was not safe to be around my children. But I had to go through a process in which he had a right to put his case forward and to make counter allegations against me, such as that I was alienating my children from not wanting them to spend time with him. And despite the ridiculousness of that accusation, given that the local authority and the police had instructed me that he was not safe to be around my children, and I still didn't know the details of his case for years. I wasn't allowed to know. It was ridiculous to think that I should be encouraging my children to think well of him. They weren't allowed to spend time with him unsupervised, and he was deemed a high risk to them. But it's the way that the system is set up, and it's actually the law itself that is the problem, because the current legal position is that, first of all, in terms of Article 8 of the European Convention on Human Rights, protects your right as a parent to a family life without, institutional involvement. Yeah, the family court is set up in such a way, it's just this very archaic way. It's not being reformed. There are plans to reform it with the introduction of pathfinder courts, which would mean that you're not pitting, former partners against each other in arguing over child arrangements. But it is set up with, applicant and responder. And that very system obviously is the worst possible thing to reduce conflict among domestic abuse couples. And we do know that it is possible to reduce conflict. And there's lots of examples of very successful mediation attempts. But the system at the moment is kind of geared towards encouraging this very kind of like litigious experience. Even when working with mediators and the police, it's become clear to us, because we do this, we're about to start delivering our victim-led training to mediators and police as well, as with the judiciary. And it's very clear that those organisations will immediately signpost to litigation if they don't feel that there is if couples are able to work together.
But what's it like to navigate these systems from the inside? Because you've already mentioned a huge number of stakeholders. We're obviously familiar with all of those because we work in that system. But to the ordinary neighbour, for all of who this is an enigma to them, how does the average survivor navigate these systems?
Very badly. I mean, there's no clear referral pathways. We've done this exercise of mapping the victim's journey when escaping from abuse. Where do you go for help? You're going to be given conflicting accounts by any agency that you come across. So you're already feeling vulnerable and fragile, probably without much resource. As Cristina said, it's extremely difficult to access legal support if you don't have the money to pay. There's maybe one not-for-profit law firm in the country, which currently only serves less than 100 clients a year. There are 5-6 not pro bono law firms in London. Half of them will not deal with child arrangements cases because they're so prolonged. And legal aid has been cut so that about 60% of domestic abuse victims wouldn't qualify for it anyway, who formerly would have. So, you're navigating a system on your own. It's like stepping into a dark world. Most victims will never have experienced a court system before. And there is no clear path forward. If you go to the police and the local authority, their most likely advice would be, if you present as a domestic abuse victim, you have to leave your abuser. Otherwise, we're concerned about the welfare of the children. We expect you to leave your abuser to protect your children. If you do leave your abuser and they make an application, a private family law application, then the expectation on the victim would be to make that child available for direct contact with that parent. And that is because of our current legislative slate, which is that, all parents have a right to family life as established in the European Convention on Human Rights, and children have an entitlement to contact with both parents pretty much at all costs. And that's even in the case where domestic abuse has been proven, even the most serious cases of domestic abuse. And in some cases, even when there's child sexual abuse.
Leah, can I say one thing? What has been really, really interesting. So I'm Italian. I chose to have a British citizenship a few years ago because one of the most important elements of British public life for me was the rule of law. And what has been so interesting is to see, yes, that there's been this extraordinary failure at the heart of a system that is supposed to cater for the most vulnerable, i.e. family courts. But what we were also able to discover through our work together on domestic abuse. Julia and I have met some of the most impressive men and women who are high court judges. And the reason that we were able to introduce a whole training program to both criminal court judges and family court judges was because one of the high court judges, upon hearing about Julia's traumatic experience over 8 years in the family courts, just said to us, look, this can't go on. This is unfair. This will ruin too many lives. Come and explain to our 60 criminal court judges in the first instance and then family court judges later, 60 judges who come together for professional development retraining. Come and tell them what it is like to be a victim of domestic abuse and to face one of you in the family court. And this openness, this ability to say, we may be making a mistake. It's not universal among high court judges, nor is it universal among family court judges, but it was an opening. And it gave us the confidence to stride in and say, actually, you do so much that is good. Your role can be transformative for the most vulnerable members of our society. But here's where you could improve. And it was with this approach that Julia really opened up a conversation, because that's how she trains judges, without revealing too much, because we know the family courts are very, very keen on keeping everything quite private. But she was able to engage in conversation with 60 family court judges and to say to them, here's where there's room for improvement. But let me tell you, this is this is where you are already doing such good work.
But may I ask a question on that? Because I'm particularly interested in what misconceptions were you confronted with as you started?
Oh my gosh, there were so many. Okay, without revealing too much, our first meeting with a high court judge who was not part of our cohort, a family court judge who was introduced to us, he basically insinuated that Julia was hysterical, that Julia was exaggerating, that Julia was all of this, whilst in the background he knew of her story because we published it in several newspapers, and we'd sent him all the details of her case. The incredible prejudice that still remains among certain judges, we cannot overlook it. And it is going to be very difficult to dismantle. We have also heard from some of Julia's mentees and some of our and some of the people we've attracted through our work. We have heard about just persistent, a blind spot when it comes to children's contact, that they must have contact and unsupervised contact with even the most abusive of parents.
But can I just say on that, this is an issue with the law. I mean, yes, there's an implementation and interpretation of the law, but it is. I mean, we have been trying to push, various amendments through Parliament with the help of our, political allies. And, it's shown me how very difficult it is to change our current legislative foundations for these discussions. And a lot of judges, I think, feel that their hands are very tied by the expectation to facilitate a relationship for children with both parents. And there is, of course, a lot of evidence that children benefit from having a relationship with both parents, and that there is a deficit when they're not able to have that relationship, or when they think badly of one parent over the other. I don't think that there is, bad reasoning behind these things. It's just that domestic abuse is very complex and is different to other, issues affecting parenting and child relationships. Where there is domestic abuse, there is more harm than child. That evidence is that there's a complete disconnect between what we know in academia and research about how children develop best and what childhood experiences are most important and can be detrimental, and where the law is. the law is in the wrong place on this stuff. Judges have to work within the law. You know, they're not looking in the family courts to kind of reinterpret and reapply it in a different way. I think that makes it very difficult for them. I think some of it is about misconceptions and misunderstandings. Some of it, they know the evidence is there and they understand that, you know, where there is domestic abuse, a child is not going to want to spend time with the parent that they've seen hurting and harming their mother or making threats to them or even harming them. But unfortunately, because of where the law is, sometimes judges are expected to overlook some of that stuff and say, well, we need to try and embed a relationship with that parent anyway.
So, Cristina, I mean, and I take the point, Julia, about this needing legislative change, not just institutional mindset change. But through your, roundtables, policy work, what resistance have you encountered to legislative reform?
I think that the psychology school is that stream is very, very embedded. So somewhere along the way, I don't know whether it was Fathers for Justice or whether it was some other lobby group, but somewhere along the way, the institution has become totally bought into the notion that direct contact with both parents is essential. And Jules, I know you say that this is legislative, but it is psychological. It's a real
It
culture.
is, but you know, from trying to submit that amendment, we're trying to push an amendment through that would force the Crown Court to consider whether the person convicted of serious child sexual assaults should retain their parental responsibility and those rights of the child once convicted. The government's already bringing in a law for those sentenced to 4 years or more, which are the most extreme end of child sex abuse crimes. And we wanted something that fits with those other ones, because those are the more serious offenders who I don't think should ever be dealt with in the family courts. The family courts do not exist to punish. The family courts are there to promote the welfare of the child, and they are not ever going to be fulfilling that purpose of punishment. That's what happens in the Crown Courts. Very difficult when you don't have a case that meets the bar for criminal prosecution, and people go to the family courts hoping for some kind of, retribution or kind of punishment. That's not what happens in the family courts. And we know from our attempts at bringing that amendment forward how Article 8, Article 8 rights are like inalienable rights. It's very, very difficult to put something in place that would enable people to sue and say that their Article 8 rights were not taken into account with this law change. So I see Article 8 as a massive barrier. I agree about attitudes and culture among the judiciary and the courts. There is an interplay between the law, the sector, how victims present, and the actors within that system, the judges and magistrates. I see how all of those pieces fit together to create this landscape that is so complex and unfair to victims of abuse.
You're completely right. But another aspect, Leah, that really struck me was the whole theory of parental alienation. And this played again and again and again in our roundtables, in drafting policy. There is this absolute conviction that there is an angry parent, a bitter parent, and a vindictive parent who happens to be the victim of domestic abuse and who is determined to alienate their child from the parent they allege is a domestic abuse perpetrator. So, although I totally agree that the law is not helping, I think that there are very deep cultural assumptions that are wrong and that are rooted in a kind of psychology that really defends the perpetrator and victimizes the domestic abuse victim even more.
The other thing that I've observed from my training with these various institutions is, these people themselves, given how prevalent domestic abuse is, it's like 1 in 4 adults has experienced domestic abuse. And, that's as a victim, as a perpetrator. And there's a lot of vicarious trauma, in particular institutions that are, having to navigate these issues. A lot of their own stuff comes up. And, we've heard the phrase domestic abuse fatigue to describe how some professionals feel who are operating in this space. Now, when one digs deeper into this, what becomes clear is there is domestic abuse fatigue. There is just this complete kind of like, ugh, can't be bothered to deal with another one of these graceful cases. There's also this kind of vicarious trauma response, which also makes people shut down and feel very fatigued and fed up of cases. And that can also come from personal experience. Now, just going to say there is absolutely no therapeutic intervention or support whatsoever for, let's say, the family courts and those operating within the family courts compared to, and I've done training across the family courts and the criminal courts, compared to what kind of thing is offered for criminal court judges, the kind of status they have in society, the kind of support, understanding of the impact of being involved in these cases has on them. Nothing at all for their colleagues in the family courts. And similarly in terms of the police and mediators and other people operating this space, it's actually very damaging. We've seen quite a important colleague in the sector who's just taken sick leave because of with a diagnosis of PTSD, vicarious trauma. They themselves had never had a personal experience of domestic abuse, but just by working on these cases over time, it's really impacted them. So I think we can underestimate also the impact of dealing with these incredibly personal domestic issues and what that has on someone, and therefore their capability to act fairly and to hear people properly, to display empathy, make people feel safe, in a safe space to give their very humiliating personal evidence on these issues.
I think what I'm struggling with, right, is that the failures in care for survivors are systemic and they're not isolated. There's data. There's an acceptance that the processes aren't fit for purpose and that legislation has shortcomings. Why do you think that institutions won't embrace this change, any kind of change, incremental change, when the evidence for supporting changes in this infrastructure is overwhelming?
I know what Cristina is about to say. I don't think the evidence is overwhelming. There is no quantitative outcomes data. No one knows what happened. I mean, working with all of these institutions, nobody knows what happens to those victims.
And that's what we want to change.
At the end of proceedings. I mean, post-separation abuse affects 90% of domestic abuse victims. And 99% of cases that go to the family courts end with direct unsupervised contact with children. So almost all victims of domestic abuse who go to court end up having to navigate contact with their former abuser, and the vast majority, always all of them, will continue to experience post-separation abuse. Where do these stats come from? They come from little qualitative studies all over the country. Some of that's gleaned from a Welsh study. There were a couple of big pieces done by UK universities. There is no quant data set. There is nothing that is considered to be unarguable evidence that shows what's happening at grand scale. And what I find is it's often dismissed as a small group of angry mothers.
Yes. What we can say is that we are exploring ways to get some quantitative data at a national level so that we can approach institutions with hard facts. And Jules is right. You can't change what you can't measure is a real mantra for the Treasury.
The other thing is, it's only not working for some people. If you're a perpetrator of domestic abuse, I don't think, and you're pretty much positive that you're going to end up with direct contact with your child unless you've committed one of the very small set of most severe child sexual abuse or domestic abuse crimes that have been sentenced in the criminal courts. And even then, why would you want to change the system? And I mean, who is it who is going to make these changes happen? Our very fragmented, piecemeal, underfunded charity sector, often by and for services led by domestic abuse victims who've stood up to try and make change happen, but and are doing an amazing job, but with underfunding and their own trauma experiences and whatever? Or is it going to come from government who've got this vague strategy, but domestic abuse is not, a priority in that strategy? Is it going to come from the courts, whose job they would say is not to change the law, to deliver the law that is given to them by politicians? There's a lot of buck passing. Like one person will say that they are responsible, that the MOJ is responsible for this, for dealing with this. And the MOJ might say that it's, the charity sector is responsible for putting the voice of victims forward, and they're funded to do that, underfunded, but whatever. It's for, it's for advocates to present their victims properly. So the law must change. We saw how these debates play out with what Cristina was talking about, the appointment of quasi-experts who have pushed this parental alienation agenda. We called on the courts to do something about the fact that there are these fake experts calling themselves psychotherapists and psychologists with no qualifications, able to give evidence on courts that has led to child removals. And the British Psychological Society said, well, we don't decide who a psychologist is. That's an unregulated term. It's not for us to regulate. And the court said, well, it is for you to regulate. It's not for us to decide who a psychologist is. It's for you to decide. And then they said to government, and then both said to government, well, we're not able to decide what a psychologist is. We need a new policy you need to regulate. And we're in this vicious circle and nothing's changed. And that's a little, a little micro snapshot of what's happening everywhere.
You're listening to the Address the Harm podcast with Cristina Odone and Julia Margo. We're going to have a short ad break.
A woman was raped? No, a man raped a woman. The Right Words campaign asks journalists, institutions, social media, and the public to change the language. Join us at therightwordsproject.org.
You're listening to the Address the Harm podcast with Cristina Odone and Julia Margo. Let's dive back into the conversation. One of the things you are responsible for, Julia, is obtaining millions of pounds of government funding for victim support. What does that tell us about the scale of the problem and the amount of funding needed to address some of these challenges, whether that's funding challenges, whether that's changing legislation, or whether that's actually meeting the needs of survivors as they go through these processes?
Well, we know that domestic abuse affects 1 in 4 adults. So the scale of the problem is vast. I don't think we even have a sense of how big an issue it is. And actually, I think about it differently in terms of the amount of funding. These things never work. But if we were actually to cost, we have been trying, but if we're actually to cost, what it costs our economy and society to deal with domestic abuse, who are the domestic abuse perpetrators of the future? One of the things that struck me the hardest was when I was doing a training session with a particular group of judges, and they spoke about some of them who'd been in post for like 20 plus years. They were seeing the same, perpetrators of domestic abuse who they had first met as child victims of domestic abuse in their homes, and had to make a decision back then about whether they should stay in the home or be removed, come back 20 years later as a parent and either a victim of domestic abuse or the perpetrator. And that cycle, the family courts, I would say, also exist to break that cycle of abuse and make their very hard decisions about whether children should remain in domestic abuse households or be moved. We find it very difficult to remove children, and there's very poor outcomes because our care system is, not operating properly. So there's very few options. The cost to society of domestic abuse is vast. The reason that children were identified as victims in their own right in the Domestic Abuse Act 2021 was because of the incredibly compelling evidence on what happens to children who are exposed to domestic abuse in their educational attainment, in their, in all aspects of their future life, and in particular their likelihood of getting into crime or committing domestic abuse themselves. Apart from most of the women that I've worked with, and men who've been victims of domestic abuse, particularly coercive control and psychological abuse, are unemployed, struggle to get into work, There was a BBC study some years ago that showed that actually many years after family court proceedings had ended, many victims of domestic abuse had still not managed to reclaim their life and go back to work. So there are many, many hidden costs of domestic abuse. And no, several £1 million would not cut it, because what we would need to see is a whole system reform of the way that the family courts operate, a whole system reform of the way the criminal courts operate and interact with the family courts in terms of what happens to somebody who's been convicted of domestic abuse and what then that does to their, what kinds of protections the rest of society and their family members need from them. We would need conflict resolution programs and therapeutic interventions for children of domestic abuse victims, to tackle post-separation abuse. We would need perpetrator programs, unless we don't believe that perpetrators can ever be rehabilitated, which I know is also a view. But if we don't believe that, then we're completely screwed. So what we would need is a complete focus on domestic abuse, which actually is a struggle in itself, because we don't like to think about domestic abuse or child sex abuse. It's something that happens secretly and privately, and we don't like to admit or talk about, even though it happens to so many of us.
Although, can I say,
Go ahead. Yeah.
one of the most interesting but also appalling aspects of having begun this work with Julia is that until very recently, if somebody asked me what I did, I never said anything to do with domestic abuse. But now, since January, and we established fair hearing then, I've been telling people at a lunch or at a drinks party or at a dinner what it is that I do. And I talk about domestic abuse, and I talk about 1 in 5 children being affected by domestic abuse. I talk about the 2 women who are killed every week by an abusive partner. Leah, after every single social occasion where I have been open about what I do, I have had a follow-up call or visit from a man or a woman who has told me that they've been living with this terrible secret for years. And it's been so eye-opening, because of course, when you're a policy, when you're a think tanker and you're studying policy, it all makes very abstract sense. But to find that people who I've known for many years suddenly come out and tell me what they've endured, it really brings home to you how riddled with domestic abuse our society is.
Yeah, this is what I was going to raise, because it's very clear that it's something that's culturally not acceptable. And I just wonder how much of the resistance from judges, for example, yes, you can pass the buck to legislative reform, but also an unwillingness to see this topic in the context of one's personal story. And that to me is very concerning, because then the officials responsible for making decisions take the mantle of causing institutional harm.
And there's another institution that is also involved in domestic abuse, and that is the family. One of the most striking aspects of Julia's story for me is how supportive her parents, her siblings have been in her journey through the family courts. At no point did Julia feel alone. The converse is true of almost every other person I've been hearing about, who feel either unable to speak to their family. This is especially true of those who live in very segregated communities, where by admitting that there's been domestic abuse, they are dishonoring their community. But it is also true of ordinary people who feel such a tenuous link with their own parents, with their own siblings, that they don't have that support system in place at all. So one of the institutions we should also be thinking about is the family, and how we can shore up these really important relational connections that can safeguard better than almost anything.
Yes, although it's 6 of one, half a dozen of the other, right? Because you've either got the cycle being perpetuated and there's not an intervention that is disrupting that, or you've got cycles of ignorance. And it's kind of
Yes,
bringing those two together and
yes.
almost getting those two to
But what is very
coexist.
interesting is when there's no support, it leaves the victim completely at a loss and unable, to heal properly. Because if you're completely alone and you feel there's no validation whatsoever.
Well, I love that you brought up healing, because the white paper that we released a few months ago was entitled From Harm to Healing: Rebuilding Trust in Britain's Publicly Funded Institutions. Now, since publishing that, we've now done polling. And the British public, 62% of them believe that survivors should be involved in institutional responses to harm, in repair where harm has been caused, and yet they're systematically excluded. How do we bridge that gap? Now, not everyone can be like Julia, but we would love to have more Julias. How can we create a situation where the survivor voice is front and center in bringing about the legislative change and institutional reform?
See, this is the thing. It's actually really easy. Anyone who works in research knows it's not easy, but it's totally doable to include anybody that you think is a stakeholder in your research. What's needed is the will. I think the will is not always there. I mean, the other thing is, I think it's sometimes difficult to put this onto victim survivors, because everything's always put onto victim survivors. And it's very difficult to have a voice. It's incredibly difficult to go into an institution that has wronged you or treated you unfairly and tell them what you want to do differently. I mean, the first time that I went to deliver training to family, criminal court judges, Cristina was supporting me. I could barely walk into the room. I was absolutely terrified to face people who had, in my experience, treated me like a criminal myself, and shamed me and held me accountable for the situations that I found myself in. And I don't want that experience to be something. I've delivered 5 trainings now. I've got more. I'm working with other institutions. It's taken a long time to get there, and given me an opportunity to platform other survivor voices from across the sector. But I wouldn't want every survivor or victim to be even offered that opportunity, because I think that can be incredibly traumatizing, frightening, and unfair.
But Julia, do you remember that very, very interesting conversation we had with one of the judges? Or maybe she was a barrister. And you said, actually, for a victim, for a survivor victim, it is not the outcome of the hearing that is so important. It is the fact that she has been heard. And validation is so important to them. And one of the things that is really a small extra expenditure for the family courts is the transcription of everything that happens in court. And if the judge can say to the victim, I have heard you, it may not be, I have heard you, and I believe that your perpetrator, deserves a fate worse than death. But just I have heard you means so much to a victim. And that can really become the first step in healing.
There have in the past also been projects where particular court circuits have invited litigants to feed back. Often if there's some kind of partnership with a university doing a study, are often extremely validating and important to victims. Christina's right. I think there's a process that should happen at the end of any court process, whether it's criminal or civil, family courts, where litigants are given the opportunity to have some notes on the judge's decision. The family courts, we call it notes on decisions. In the criminal courts, it's sentencing remarks, and they're just not routinely shared in this country with litigants. And I think that's a real shame. As Cristina said, most of the time, someone who doesn't get the outcome they were seeking in court will leave feeling that they weren't heard and weren't believed. And actually what might be going on is that the judge is thinking, I do think that you've experienced severe domestic abuse. I don't think, given where the law is and given where the culture is, that means that I can limit the contact that your child has with the other parent. And I hope that, you will be protected from that in some way, and the child will grow up and be able to have that relationship. But I believe that you have experienced domestic abuse. That doesn't happen. And I that's one of the things that we're working on. I think it does need to happen, and it would help people to overcome and live with things. And Christina's quite right. The outcomes is not the only thing that matters to them. I mean, if it was, then, less than 1% of litigants would survive the family court process, because, as I said, direct contact is generally the outcome that happens, whatever the severity of the domestic abuse you've experienced. But the process of feeling validated, heard and believed is very important, particularly to somebody who's been a victim of coercive control. What that means about how you then engage them in systems reform, I don't know. I mean, there are many attempts to do that by, calls for evidence, and the Domestic Abuse Commissioner in this sector has done quite a lot to try and platform survivors' voices. I don't know how much that trickles down and overall improves trust and makes people feel that those institutions are accountable to them. So I don't know.
We've talked about judges, and we've talked about policymakers, we've talked about families, and we've talked about victim survivors. What would you say to a chief executive or senior leader who is perhaps employing some of these individuals who are going through this in their personal story, who thinks this is a non-issue or struggles to see domestic abuse as a public health issue?
I mean, I think that it is really important to remember the numbers, because although, as we keep saying, the data is not very strong, even if it's only 1 in 4 women and 1 in 11 men who have undergone this kind of abusive behavior, that is a huge number, and any CEO should be very, very conscious of the impact on productivity, on the impact on their mental health, on the impact on the culture of the place. If you know that there's somebody in your workforce who has been abused in any number of ways, showing them that you support them and making that be part of your office culture is, I think, incredibly empowering for the entire staff. So I think recognizing it and addressing it is really, really important. Signposting is something that is so tricky, because it is such a patchwork across the country of support services. So I would have to say, my heart would go out to any CEO who wants to be actually very active and very practical and tell their staff member, this is where you should go, this is what you should do next. But if they are showing willingness to listen and to support, I think that will not only have a huge beneficial impact on that particular employee, but it will have a trickle-down impact on the entire staff.
See, my concern is, I mean, I know Christina's done a lot of work in the past to have domestic abuse recognised as a public health issue. And it is a public health issue, because when you look at the health outcomes from the limited qualitative data research that has been done, it's really clear that the outcomes are really harsh. I mean, I was very unwell. I was diagnosed PTSD. And I really would say that I lost my cognitive function for a time. The problem is, when we start talking about the impact on domestic abuse on victims, again, I feel that people look to the victim survivor and say, well, then how are you employable? How can you care for your children safely if you have PTSD and mental health problems as a result of this stuff? What I would say is PTSD and the health impacts of domestic abuse are treatable, and one can recover. I've recovered. And I was, I was running my own company at the time, and I was able to take time to engage in therapeutic interventions that would help. And it wasn't such a particularly extensive recovery period. It was just really important to have time to do that. If we believe that these are public health. This is a public health issue, that it is not the victim survivor's fault that they were exposed to this issue that has impacted their mental health. And we believe that it's possible to recover, which surely we must believe it's possible to recover because people do recover. Then I do think there is an obligation, a social responsibility to say that we make time and space for that to happen. But we can't put it onto victim survivors and say, and that's what I'm scared of when we really look at the data and the health implications that people suffer from after court. I think it points into a narrative where we say, and which I've seen happen, is that person going to be capable of parenting their children if they've just escaped domestic abuse?
What hope can you give to that person who is stuck in the broken system right now?
Pointing to Julia. Invite them to meet with Julia.
Look, my children and I went through that system many, many times. And actually, it's transformed since my experience. It's much better than it was. It might not feel like it, but it is. We survived and we were able to recover and move on. And that's partly because of the resources and the support that we had around us, as Cristina said, but it's not only because of that. There are many, many survivor networks and support groups. One of the things that we think is really needed, rather than creating lots of amazing new programs, is to just have some kind of pathway, like a referral pathway or navigation tool to help victims find and identify the support that's available to them. There is actually incredible support both outside the family justice system and within. And if people know to ask, it can be a lot better. I would say that in my experience of working with these various institutions, there is huge will to change and improve. A lot needs to happen, but there are many, many people working together. And that's one of the beautiful things that I've seen by really diving into this area rather than mentoring on the side of the system. There's huge will to change. There are some exceptional people working to try and make it happen. And I believe that it will change and it will improve. I believe that we will achieve law change that's needed to rebalance the scales of abuse victims. I believe that all of the professionals working in domestic abuse will improve with training that they are immersed in. And so to me, I wouldn't be working in this area if I didn't think there was the potential for change. I've seen so much change since we started working in this area and have met so many incredible people working to deliver that change. So personally, I think it is unavoidable that change is going to happen.
I love that. I've loved this conversation. Thank you for sharing so freely and so wisely about the work that you are knee-deep in all day, every day. I hope you've enjoyed being a part of this conversation, and it's been really great to meet both of you. It sounds like there are lots of ways that we might be able to work together, both from an advocacy, but also a survivor voiceless perspective, and I look forward to exploring those in coming weeks and months.
Thank you so much, Leah. It was a real pleasure.
This is the Address the Harm podcast for the Coalition for Institutional Accountability. You can be part of changing broken systems. Follow Address the Harm on social media. Visit addresstheharm.org to support our campaign. Every donation funds our fight to stop institutions investigating themselves. Why not share this episode and join our movement? You've been listening to the Address the Harm podcast. We hope you've enjoyed this episode. Copyright 2025, production copyright Leah Talks Limited, all rights reserved.